Property taxes, one of the most abhorrent invasions of God-given rights. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll be presenting a lecture on a topic that I have been so giddy to present on. That topic for today's lecture is going to be property taxes. Now, of course, we're going to be dissecting the whole process, the legitimacy, constitutionality, principle, everything like that in the context of the state of Texas. But when it comes to the principles, when it comes to the legitimate standing, I should say that in quotes, the principles in general are going to apply universally to any state and the state governments that believe they can ever deprive you of any portion, steal away any portion of the results and the products of your labor. So there's going to be a few ways that we're going to attack this. First, I'm going to walk you through the foundational principles upon which, yes, of course, the U.S. government was formed, but before that, with the state governments. And then, of course, in the modern context, with using a Texas bent, how property taxes to this day are unconstitutional, illegal, and an invasion of God-given rights that cannot be allowed or permitted. After that, we're going to go into the actual statutory standings and the constitutional provisions which support the position that property taxes are unconstitutional as declared by the Texas Constitution. Definitely the way that they're being levied and waged, the property taxes are being waged. After that, I'm going to show you a couple of Texas laws that define exactly what sort of metric that the state tries to use whenever they impose this property tax. Then I'm going to show you the Texas rules of evidence and how you as an individual citizen no longer have to wait on the Texas legislature to finally fulfill that promise of getting rid of property taxes. And instead of depending on them to uphold their oaths, which they've made very clear they're not going to do, their oaths to the Texas Constitution, which every Texas state official has to take, instead of depending on them to enact their good wills, how you, the individual Texas citizen, can go about directly and significantly contesting and deterring this obvious, irrefutable invasion of your God-given rights. Okay, so let's start out with the first mode that we're going to attack this from, that being the foundation, the principle of what exactly property is and who can put their hands on your property. What even is property? Is it just land? Is it just houses? Or is it more than that? And to what extent can you protect those things? The first individual I want to show you today is Mr. William Blackstone. And the reason I want to show you Mr. William Blackstone first and foremost is because it's pretty well universally accepted by historians and most legal scholars, which that doesn't really hold any bearing. It just shows that this isn't crazy Caleb up on a soapbox. William Blackstone, almost universally agreed, is the individual that basically constructed the understanding of the founding generation whenever they went about formulating what a judiciary, what the courts, and what law with a capital L was supposed to be. And the reason he was so influential in doing that is because he wrote something called the Commentaries on English Law, or on the Laws of England. And while he was scrutinizing English law, somewhat subtly, but also directly, he explained, in general, the origin of law with a capital L in totality, providing a framework, kind of like the U.S. Declaration of Independence did, providing a framework for something much bigger than just a critique and a scrutiny of English law. So I want to direct you to look at his second book, or book the second. There are compilations publicly available on the internet of all his commentaries compiled. You can look to his second book, which is summarily titled Of the Right of Things. And it's in chapter 1, so you don't have to look very far. Of course, I would encourage you to read all chapters 1 through 16, because he gives some very interesting insight on the relationship between something like a monarch and well, not a peasant, but a subject, and how that can find equivalencies in republic and non-republic forms of government as well. But at the onset, Mr. Blackstone, who again, almost unilaterally determined how the founding generation was going to formulate the judiciary and law with a capital L, he says this about property. And you're more than welcome to read this first part. He's just summarizing what the previous book was about. So again, as always, I encourage you, go read this for yourself so that way there's zero concerns about mischaracterization. He says on the outset in chapter 1 of book 2, origin of the right of property. We're going to read this sub-explanation as well. There is nothing which is so generally, or which so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole, and take note of this, this is gravitas language, or that sole and despotic dominion, which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe. You have singular, unitary control, complete control over your property. And yet there are very few that will give themselves the trouble to consider the original and foundation of this right. So let's exactly see what he believes to be the origin of that right, the right to property, which no one can invade upon. Like he said, sole and despotic dominion, which one man, you, claims and exercises over the external things of the world. He says, the chapter treats of the nature and origin of the rights of property. The only true and solid foundation of man's dominion over external things is the gift of the Creator to him in the beginning. At first, all was in common. So at first, everything was shared, and everyone took from the public stock to his own use such things as his immediate necessities required. This community of goods was ever applicable to the substance of things, but not to their use. Use gave transient property, the right of property lasting only so long as the act of possession. With the increase of the race, so as mankind grew in numbers, the conception of more permanent dominion became necessary. Why? Because you would have this constant infighting of, well, who got to it first? Who laid claim to that property first? That's what he's saying here about use. The property is yours because you're using it. Well, as numbers grew, it became more and more difficult to understand and determine reliably who exactly was using that property first. So it was very difficult to determine who actually had a legitimate claim to the use of that property. And any property was soon established in every man's house and homestall. Movables were first appropriated before the soil itself, then came property in flocks and herds. Hence arose the right to certain tracts for pasture, to certain wells, etc. Okay, so we have this individual, and you're welcome to read this here. He's just going on further explaining what we were just talking about with mankind growing in numbers. It became difficult to determine the title of initial first use of the property. So we have Mr. Blackstone, who, again, basically unilaterally determined or set the framework for how the founders were going to construct the judiciary, going to construct the courts, and going to construct law with a capital L, saying you have a sole despotic dominion over your property, which you get to exercise power of to the exclusion of the right of any other individual in the entire universe. No government, no man, no assessor officer can take your property from you, can even step on your property without your permission. Well, Caleb, that's just one guy. And he was obviously critiquing English law. So that definitely doesn't play into how the founding generation went about constructing the U.S. government. And then, of course, how the subsequent Americans or U.S. individuals who migrated to Texas then went and constructed the Texas government. Okay, how about Mr. John Locke and his second treatise of government? John Locke, which is another one of those individuals, you can think of it this way. Blackstone basically provided the framework for the judiciary that the founding generation used. John Locke, again, this is another one of those universally agreed upon, or almost universally agreed upon individuals that influenced the founding generation's thinking. If Blackstone provided the framework for the judiciary, John Locke provided the framework for the legislature and legislation, and how the powers of government are to be exercised at maximizing the capacities of the individual, also while limiting any sort of powers that will be exercised by the government. So let's see what Mr. John Locke has to say about property, and he says quite a bit. So first, we're going to start out, here you see, the Second Treatise of Government by John Locke. I'm going to skip down to page 99 of this chapter, or of this version. This section is located in chapter 14, and it's in paragraph, or he has them in sections, section 222, and he says this: the reason why men enter into society, the reason they form governments in the first place, is the preservation of their property. So if a society, if a government, if a collective goes to an extent of confiscating your property because you're not obeying with this arbitrary tax that society believes can levy on you, is that still serving that purpose, that reason men enter into society? Obviously not. So if a society goes to steal your property through something like a property tax, it's disobeying and no longer serving one of its sole reasons, one of its exclusive reasons for existing and being instituted. And the end why they choose and authorize a legislative is that there may be laws made and rules set as guards and fences to the properties of all the members of the society, to limit the power and moderate the dominion of every part and member of the society. For since it can never be supposed to be the will of the society that the legislative should have a power to destroy that which everyone designs to secure, so again, if a legislative begins invading upon that reason of protecting the property of the individuals, there's no reason for that legislative to exist. By entering into society, and for which the people submitted themselves to legislators of their own making, whenever the legislators endeavor to take away and destroy the property of the people, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any farther obedience, and are left to the common refuge which God hath provided for all men against force and violence. Whensoever, therefore, the legislative shall transgress this fundamental rule of society, buckle yourselves up, and either by ambition, fear, folly, or corruption endeavor to grasp themselves, or put into the hands of any other, an absolute power over the lives, liberties, and estates of the people, by this breach of trust, they forfeit the power the people had put into their hands for quite contrary reasons, and it devolves to the people, who have a right to resume their original liberty, and by the establishment of a new legislative, such as they shall think fit. And what does that sound like? Remember the U.S. Declaration of Independence. Whenever a government becomes destructive of these ends, it is the right of the people to reform or abolish their government and institute a new one in whatever form they think expedient. Provide for their own safety and security, which is the end for which they are in society. This isn't the only time that John Locke talks about, and this is just the second treatise. This is not the only time John Locke talks about this God-given, secured right to liberty. Let's skip back a few pages to page 64 of this PDF version. This quote is located in chapter 11, same book, chapter 11, section 138, and he says, thirdly, the supreme power cannot take from any man any part of his property without his own consent. Remember that. Keep that in the forefront of your mind, because that's going to be a key principle whenever we go through the Texas Constitution, Texas law, and how, of course, you can go about protesting and providing an affront to this encroachment on your God-given right to property, which John Locke is saying is a betrayal of a legislative's purpose without his own consent. For the preservation of property being the end of government, so the whole purpose, the true end of government, is to protect you, the citizen, in your property. So when a government goes to the opposite of that, like confiscating and selling and auctioning off your property because you refuse to pay an illegitimate tax, John Locke says, and that for which men enter into society, it necessarily supposes and requires that the people should have property, without which they must be supposed to lose that by entering into society, which was the end for which they entered into it. Too gross an absurdity for any man to own. Men, therefore, in society having property, they have such a right to the goods, which by the law of the community are theirs, that nobody hath a right to take their substance or any part of it from them, and again, without their own consent. Without this, they have no property at all. For I have truly no property in that which another can by right take from me when he pleases against my consent. And again, this isn't the only time Locke talks about property. He talked about it again in chapter 9 of this same book. So we're going to skip back a couple more pages. This is located again in chapter 9, section 124. And he makes it blatantly clear here. Section 124. The great and chief end, therefore, of men's uniting into commonwealths and putting themselves under government is the preservation of their property, to which in the state of nature there are many things wanting. So if there's any question about what the founding generation thought regarding the right to property, not just being this metaphysical, oh yeah, you have the right to your ideas and your speech and your expression. No. In fact, in the original draft of the U.S. Declaration of Independence, one of the complaints that was listed was the king confiscating the property of the colonists. And it doesn't say without representation. It just says because the king was taking our property. That's it. If there is any question about the breadth of ownership, of total dominion, to use Blackstone's own words, regarding you and your property, your house, your land, Blackstone included the minerals underneath your ground, underneath your land, and underneath your house. He included the air above your home. All of that was yours. And reinforced by John Locke, no one can invade on that. In fact, the whole purpose of government and societies is to make sure you don't have to worry that that will be invaded, that that will be an attempted encroachment of the government or society upon which and into which you entered. Okay, well, that's just two people, Caleb. I don't care how influential they were. I don't care that most of the things John Locke said were almost copy-paste quoted by the founding generation. That's just two people. Okay, how about Mr. Samuel Adams, who is often referred to as the father of the American Revolution? What does he think about property? So in his The Rights of the Colonists expose, kind of a supplement to the U.S. Declaration of Independence, he doesn't give a vague picture of this either. He addresses it directly, kind of like what the original draft of the U.S. Declaration of Independence did. He says, among the natural rights of the colonists are these. First, the right to life. Secondly, to liberty. Are you starting to see the influence that he had on the U.S. Declaration of Independence? Secondly, to liberty. Thirdly, to property. Together with the right to support and defend them in the best manner they can. These are evident branches of, rather than deductions from, the duty of self-preservation, commonly called the first law of nature. You're welcome to read these sections as well. As always, please read through the entirety of these documents, especially the first two. If you want a very comprehensive, definitely time-consuming, but comprehensive understanding of the ideals that the founding generation was alluding to, Blackstone and Locke will greatly help you in that endeavor. But further, Samuel Adams, the father of the American Revolution, says every natural right, not expressly given up, or from the nature of a social compact, necessarily ceded, remains. Do you ever, well, and you're welcome to do this, do you ever consent to having your property taken? To having any percent of your property taken? Do you ever like or feel benefited? Do you have any evidence that you're benefited from your right to property being invaded by the government? If not, the father of the American Revolution says, if you don't consent to that surrender, the surrender never happened, which means your property remains uninvaded, inalienable. Further, all positive and civil laws should conform as far as possible to the law of natural reason and equity. So even if there is any part in any constitutional document for that part, those provisions to be sound, to be just government, the father of the American Revolution is saying those clauses, if they're going to be placed there in the first place, they have to be construed to submit to the law of natural reason and equity. And what does that include? That includes these God-given rights. Facilitating these God-given rights, that among them being to life, to liberty, and to property. I think those are the only sections I highlighted. Okay, I'm glad I scrolled further down. So he goes on to explain this exact principle, showing exactly where he's getting these ideas from, and you'll see throughout many of these documents, they're constant allusions to, not illusions, allusions, references to God, to the ultimate arbiter of the entire universe. And he says, in short, it is the greatest absurdity to suppose it in the power of one or any number of men at the entering into society to renounce their essential natural rights. And what were those? Life, liberty, property. Or the means of preserving those rights, when the grand end of civil government, reiterating what Locke, reiterating what Blackstone said, the grand end of civil government, from the very nature of its institution, is for the support, protection, and defense of those very rights, which are life, liberty, property. The principle of which, as is before observed, are... Oh, I shouldn't have interjected. Just keep reading. As is before observed, are life, liberty, and property. If men, through fear, fraud, or mistake, should in terms renounce or give up any essential natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. So even if you have these government officials, even if you have a society that comes up to you and says, well, we can't fund roads, we can't fund schools, we can't do all of these things that facilitate your benefit unless you surrender a portion of your property, a portion of the produce of your labors. Even if, from the side of that, you consent to renouncing that portion of your property, Samuel Adams, the father of the American Revolution, is saying, no, because if we apply the, what did he say, what did he call it? The natural law of reason, the eternal law of reason, that overrides that fear, that consent under duress. Which means the clauses you're going to see in the Texas Constitution in Article 8, talking about, well, the counties can assess on this and assess on this, and the cities can assess on this, and they can take a portion of this and that and this and that. Even with all of that, Samuel Adams is saying, because that's made under fraud, under fear, or any other form of deception, the eternal law of reason renounces that, considers that consent under duress, and voids it. vacates it, which means they still don't have a right, don't have the authority to collect any property or levy any tax on your property. The eternal law, did I skip a line? I did not. Let's go ahead and reread that one. The eternal law of reason and the grand end of society would absolutely vacate such renunciation. The right to freedom being the gift of God Almighty, it is not in the power of man to alienate this gift and voluntarily become a slave. And I think that was, well, good grief. I should have reviewed these notes better. So we go down into this third section where it's summarily titled The Rights of the Colonists as Subjects. So now he's talking about when he's explaining before the U.S. Constitution, before the Articles of the Confederation, before this idea of the states separating, he's making this appeal to that eternal law of reason and stating verbatim to the face of the monarch, this is the inalienable right of the colonists as current subjects of you, the monarch. And you are betraying the trust they instilled in you to protect this right. He says, thirdly, the supreme power cannot justly take from any man any part of his property without his consent in person or by his representative. Oh, well, Caleb, we got you there, because the Texas legislature, they are representatives and comprised of representatives of the counties and therefore of the citizens. Okay. If the citizen votes, I don't want to surrender my property or any percentage of it, any percentage of a arbitrary value of it, but then a representative goes to the legislature and says, yep, we're going to take a percent of the value of that property. Is that representative? Not remotely. In fact, if I was an attorney and someone hired me to be their attorney, to be their counsel, and I did something that they told me not to do, or I didn't do something they told me to do you know what happens to me? I get reprimanded and potentially disbarred. That's legal misconduct. So no, if a representative goes and advocates for positions such as property taxes and the encroachment upon the God-given right of property, when the citizens are trying to uphold and protect their God-given right to property, that representative is not thereby overruling and effectively litigating, or not litigating, legislating as an entity of the people. In fact, he's instilling his own will, and thus no longer acting as a representative of his district, of his county, no matter the size of the demographic he's supposed to be representing. If he betrays the will of the people he represents, he is no longer a representative. Last, he says, now, what liberty can there be where property is taken away without consent? If you have these God-given rights to life, liberty, and property, how could it possibly be feasible that there is ever a situation that you have these inalienable rights to things like life, liberty, and property, but also this supposed right that many historians try to argue provides government something like eminent domain? How is it that you have an inalienable right to property, but then the government can invade that property, can invade that right? It's either inalienable or it's invadable. You can't have it both ways. And that's exactly why the founding generation didn't carry over the power of eminent domain. Okay. Well, Caleb, sure, that's three people now. We have the individual who basically provided the framework for the judiciary of the U.S. and then of the subsequent states. Well, the states were first formed and then the U.S. You have John Locke, who provided the framework for the legislature and legislating. You have Samuel Adams, who's the father of the American Revolution, but that's still only three people. This was probably a fringe idea. You know, Samuel Adams was kind of an extremist, kind of an anarchist, absolutist sort of position. Okay, how about the second president of the United States, Mr. John Adams, who wrote in, let me see, it's Discourses on Davila. That's how you spell Davila right there. And he mentions on page 9 of this PDF version, again, as always, go read these documents for yourselves in totality. He says here on page 9, please take notes of this. The moment the idea is admitted into society, remind yourselves, what is the grand sole end of society and government? To preserve the property of the citizens. And what is the property of the citizens? Blacklock said the sole despotic dominion which you exercise over the external things of the world, which no one in the universe can invade. So John Adams, second president of these United States, says, the moment the idea is admitted into society, that property is not as sacred as the laws of God. Caleb, they were just deists. It's such a ridiculous lie. The founders were not just deists. They were Bible-thumping Christians. That property is not as sacred as the laws of God, and that there is not a force of law and public justice to protect it, anarchy and tyranny commence. If thou shalt not covet, and thou shalt not steal, were not commandments of heaven, they must be made inviolable precepts, inviolable precepts in every society before it can be civilized or made free. And we have to remember what's so important about John Adams saying that is he was the president to implement the Alien and Sedition Acts. And if you're not familiar with the Alien and Sedition Acts, the sedition part of those acts was enforced by the Adams administration, during which he would send federal officers to these press rooms and these press offices to destroy the press, because those certain press offices were publishing papers that were dissenting and criticizing the U.S. government. So for a president who went and enacted ideas that invaded upon property, to say that the moment property is no longer revered equally to the laws of God, then you have tyranny and anarchy. It's such an important principle that that contrast of importance is what makes his opinion so unique, so different. That in this instance, he was willing to, for whatever reason, probably loyalty to the Union before the actual structure of the U.S. government, was willing to destroy that God-given right, property. But because of his contradiction in his actions, he proved his own point that tyranny and anarchy commenced. Because if you're not sure what the aftermath of the Alien and Sedition Acts were, you should definitely look into that. Probably start with the Virginia and Kentucky resolutions of 1798. It wasn't anarchical, and it wasn't, well, it was certainly tyrannical, but it got pretty darn close. If there was a time before 1860 that the states got close enough to an immediate dissolution of the Union, it probably would have been then, which is kind of funny because that was only 10 or 12 years into the U.S. Constitution having been implemented and imposed. Anyway, it's called the nullification crisis era in the public education textbooks. But that was the aftermath. So for him to say that whenever we no longer respect property, it's going to lead to tyranny and anarchy, and then for him to, during his administration, not respect property, and then it lead almost to anarchy and certainly to tyranny, proved his point, which is why his opinion, of course, is so important. Okay, well, that's just four people. It doesn't matter that you have the second president of these United States saying that. It doesn't matter that you have John Locke. It doesn't matter that you have Blackstone. It doesn't matter that you have the father of the American Revolution saying that. Those are just fringe ideas. That wasn't the popular understanding. Okay. What about James Madison, the father of the U.S. Constitution, who spoke directly to this? And I'm sure it comes as no surprise. His position is almost copy-paste of the positions of Blackstone and of John Locke and Samuel Adams. So here we have the father of the U.S. Constitution, James Madison, elucidating us on exactly what property is. He says this term, he's referring to property, in its particular application means, quote, that dominion which one man claims and exercises over the external things of the world in exclusion of every other individual. Please skip back 10 or 15 minutes when we were reading over Blackstone, because that is a copy-paste of what Blackstone says. So I don't want to hear any Blackstone didn't influence the founding generation. I don't want to hear any of that bogus. Further, he says, in its larger and juster meaning, so not only the land, not only the houses upon that land, not only the air above the house, not only the ground below the surface is property of yours. Madison says, in its larger and juster meaning, it embraces everything to which a man may attach a value and have a right, and which leaves to everyone else the like advantage. In the former sense, a man's land or merchandise or money is called his property. In the latter sense, a man has a property in his opinions and the free communication of them. He has a property of peculiar value in his religious opinions and in the profession and practice dictated by them. He has a property very dear to him in the safety and liberty of his person. He has an equal property in the free use of his faculties and free choice of the objects on which to employ them. In a word, as a man is said to have a right to his property, he may be equally said to have a property in his rights. So well and concisely put. Well, Caleb, those are just men. These aren't policies, these aren't laws, these aren't governing documents, these are just merely opinions. Sure, they're the opinions and beliefs of the people who constructed the very governments we pretend to obey today, but they're just opinions. They're not actual policy, they're not governing documents, they're not constitutional provisions. Okay, what about the Texas Declaration of Independence? Which, as you see here, again, please always go read these documents in its entirety for yourselves. Yes, if that gets exhausting to hear, please forgive me, because the only reason I do it is to reiterate constantly for the sake that there is zero concern about mischaracterization, misinterpretation, whatever. The unanimous Declaration of Independence made by the delegates of the people of Texas in General Convention at the town of Washington on the Brazos on the 2nd day of March 1836. They started with this. So, up front, the prioritized information. When a government has ceased to protect the lives, liberty, and property of the people, from whom its legitimate powers are derived, and for the advancement of whose happiness it was instituted, and so far from being a guarantee for the enjoyment of those inestimable and inalienable rights, becomes an instrument in the hands of evil rulers for their oppression. When the Federal Republican Constitution, they're talking about the Mexican Constitution at the time, of their country, which they have sworn to support, no longer has a substantial existence, and the whole nature of their government has been forcibly changed without their consent from a restricted federative republic composed of sovereign states to a consolidated central military despotism in which every interest is disregarded but that of the army and the priesthood, both the eternal enemies of civil liberty, the ever-ready minions of power, and the usual instruments of tyrants. When long after the spirit of the Constitution has departed, moderation is at length so far lost by those in power that even the semblance of freedom is removed and the forms themselves of the Constitution discontinued, and so far from their petitions and remonstrances being regarded, the agents who bear them are thrown into dungeons and mercenary armies sent forth to force a new government upon them at the point of the bayonet. Whenever a government invades on the inestimable and inalienable rights of, what were they? The exact same three as the father of the American Revolution stated: the rights to life, liberty, and property, that government is no longer owed allegiance. Okay. Hopefully, that has provided enough basis. If not, believe it or not, I have many other sources, but I can see this is already hitting the 40-minute mark, which is absurd, but I want to be thorough with this position because it is not a jovial task to say that something that a government is doing is unconstitutional, illegitimate, and warrants being vacated. nullified and completely disobeyed, as this will soon evidently become clearly the correct path to take regarding something like property taxes. So that in totality has provided the framework. So remember yourself of that, or remind yourself of that for the remainder of this lecture. You have an inalienable, inestimable right, according to the authors of the U.S. government, according to the Texas Declaration of Independence, according to the individuals who influenced the founding generation of the U.S., and of course, the preceding state governments. You have an inestimable, and I have to work on pronouncing that word, inestimable, inalienable right to property, which cannot be invaded by any government, by any man. In fact, the whole purpose, according to those same individuals, those same documents, for a government, a society to exist, is to preserve your right to property. So if at any time that society or government acts in contrary to that, such as confiscating your property for not paying a property tax, you no longer owe any obedience. Definitely in that sector, or definitely in that exercise of power, to obey or comply with that society or that government. So now that we've dealt with that framework, let's contend with a Texas-centric context. And I want to start, as is wise, with the Texas Constitution. And the first section we're going to be looking at is the Bill of Rights in the Texas Constitution, which is Article 1. And in Article 1, as you can see there, titled Bill of Rights, Article 1, Section 9, this one has been interpreted incorrectly to apply only to things like police officers and detaining and arrests. But it actually reinforces and formally acknowledges what we were just talking about, that you have an inalienable, inestimable right to life, liberty, and property. And that, like John Locke was saying, the only time that is to be ever given away is with your own consent. Samuel Adams said, actually, if you give your consent, the eternal law of reason would renounce that, because obviously you're only doing it under duress. But if we're going to play with this idea that anyone is entitled to your property, your God-given right to property, it has to be surrendered with your consent. And that's what Article 1, Section 9 is formally acknowledging. It says, searches and seizures. The people shall be secure in their persons, houses, papers, and possessions. From what? All unreasonable seizures or searches, and no warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause supported by oath or affirmation. So again, apply that foundational understanding. You are secure in your persons, houses, papers, and possessions. Remember what John Adams said. Thou shalt not steal. If that's not written in the laws of heaven, if I remember correctly, then we must establish it as an eternal precept of society. No one is entitled to your property. And if you are to surrender any portion of your property, or any made-up, arbitrary, numbered value of your property, it has to be with your own consent. So there's Article 1, Section 9, establishing formally your right to be secure in your person, houses, and your possessions. Further, Article 1, Section 17, taking property for public use, special privileges and immunities, control of privileges and franchises. So let's just say, for the sake of argument, you consented to surrendering your property to the state of Texas. The Texas Constitution says, no person's property shall be taken, damaged, or destroyed for or applied to public use without adequate compensation. How do you determine what's adequate? Is it whatever the government determines to be adequate for you? No, because that's not consent. You're not consenting to your property being taken, which means you as a citizen have a God-given right to first your property and thereby whether or not your property is surrendered and taken. You have an inalienable right to be a party to determining what is adequate compensation, without adequate compensation being made unless by the consent of such person. And only if the taking, damage, or destruction is for 1. The ownership, use, and enjoyment of the property, notwithstanding an incidental use by A. the state, a political subdivision of the state, or the public at large. B. An entity granted the power of eminent domain under law, which there is no such thing as in the Western context. Eminent domain was an English law practice that was not carried over into these United States, and you can see that clearly refuted by the sources, and of course many other sources that we were just going over. Blackstone, John Locke, Samuel Adams, John Adams, James Madison. Eminent domain was not carried over. Or 2, the elimination of urban blight on a particular parcel of property. B, in this section, public use does not include the taking of property under subsection A of this section for transfer to a private entity for the primary purpose of economic development or enhancement of tax revenues. C, on or after January 1st, 2010, the legislature may enact a general, local, or special law granting the power of eminent domain to an entity only on a 2/3 vote of all the members elected to each house. They can't do that. D, when a person's property is taken, which it can't be, under subsection A of this section, except for the use of the state, compensation as described by subsection A shall be first made or secured by a deposit of money, and no irrevocable or uncontrollable grant of special privileges or immunities shall be made, but all privileges and franchises granted by the legislature or created under its authority shall be subject to the control thereof. The next article, and this is going to clarify what I've been saying for Article 1, Section 17, and of course Article 1, Section 9. The next section we're going to look at is Article 1, Section 19, which makes unequivocally clear the formal recognition and the supporting, the buttress of those very ideas and principles that we were just going over with Blackstone, Locke, Adams, Samuel and John Adams, and James Madison. Section 19, deprivation of life, liberty, property, etc. by due course of law. No citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disfranchised, except by the due course of the law of the land. And why is that? Now, of course, Samuel Adams would say, even in that situation, you can't renounce your God-given, inalienable, inestimable right to property. But the reason that clause has any chance of lasting is because by living in Texas, you give implicit consent to obey the laws of Texas. Otherwise, what's the point of living in Texas? What makes Texas unique? Well, there are many things that make Texas unique, but specifically, with governance, what makes Texas unique? The Texas Constitution and the laws that are legislated in pursuance of the Texas Constitution. And by you being a resident in Texas, you give your consent to obeying those laws, to obeying the Texas Constitution. To make absolutely certain that these are inestimable, inalienable rights, the Texas Constitution gives a formal acknowledgement. Article 1, Section 29. This is an infinite clause, everlasting clause, kind of like what I think it was Adams talked about. No, it was Samuel Adams. So technically Adams. I was referring to John Adams. Anyway, Samuel Adams, the eternal law of reason. Article 1, Section 29 of the Texas Constitution. Bill of Rights accepted from powers of government and inviolate. No matter what the government tries to do, it cannot impede, interfere, any way alter the Bill of Rights. To guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government, and shall forever remain inviolate, and all laws contrary thereto, or to the following provisions, shall be void. Well, Caleb, there are parts of Article 8 that are kind of confusing, that say counties can assess at this, and they can collect property taxes, and this and that. It doesn't matter. Because Article 1, Section 29 says that whatever is in the Bill of Rights is forever inviolate. And anything the government tries to do, which would even implicitly violate any right formally acknowledged in the Bill of Rights, according to the Texas Constitution, all laws contrary to the Bill of Rights are void. So you're secure in your person, property, or your person, your possessions, houses, property in general, from all unreasonable searches and seizures, and you cannot be deprived of life, liberty, or property without due course of law. And neither of those can ever be violated by any act, by any law of the Texas government. So now let's get down to the article in question, which is Article 8, regarding the powers of taxation. See here, Section 1, equality and uniformity of taxation, taxation of property in proportion to value, occupation, and income taxes, exemption of certain tangible personal property and small mineral interests from ad valorem taxation. Ad valorem taxation, ad valorem is just Latin for according to value. So, speculative. If someone was to buy this, what would they pay for it? That's the simplistic definition of ad valorem, according to value. Valuation of residence, homesteads for tax purposes. Valuation of residence, homesteads for tax purposes. That was not a continuation. That was supposed to be an end of the title. So here we have at the onset, subsection A, taxation shall be equal and uniform. So any of these exceptions, any of these exemptions to these taxation requirements would have to be thrown out, because that wouldn't be equal and uniform. What you'll hear from these state-approved attorneys is, well, it's equal and uniform among those different parties. It's equal and uniform among the homesteaders, and it's equal and uniform among the farmers and of the people in those occupations. But in actuality, that's not equal and uniform, because if that's the case that the attorneys are trying to argue, that would still be unequal, because now you're providing an unequal favor to farmers, to people in certain occupations, to homesteaders, compared to anyone who is a non-farmer, or someone not in those occupations, or someone who is a non-homesteader. So no, you can't have exceptions and exemptions and still try to uphold this idea that taxation shall be equal and uniform. It's a contradiction. It's not even paradoxical, it's a contradiction. You can't have it. So B, here's where everything gets up in an uproar. All real property and tangible personal property in the state, unless exempt, is that equal? Is that uniform? No. Unless exempt as required or permitted by this Constitution, whether owned by natural persons or corporations other than municipal, shall be taxed in proportion to its value, which shall be ascertained as may be provided by law. Again, we have to remember, not only the sections in Article 1 of the Texas Constitution, which secure you in your houses, persons, property, everything of the like, and that if you're going to be deprived of property, it has to be by due course of law. And then, of course, those rights being forever accepted from the powers of any general government. Can the Texas state government actually enforce this provision? No. No. It has to be, if we're going to toy with this idea, if we're going to neglect virtually every influence of the founding generation and many of the founding generation of themselves. If we're going to neglect that, if we're going to neglect the Texas Declaration of Independence, if we're going to basically throw out any sort of historical support, if we're going to get rid of all of that, would this be true? Sure. But again, you would have to get rid of everything that makes this Constitution a Constitution. You'd have to get rid of the Texas Declaration of Independence. You'd have to neglect the founding generation. You'd have to neglect the very ideas and the people who influenced the creation of this document. And you know what their ideas said? Their ideas say that an act like this is completely illegitimate and has to be disobeyed. Further, if you look at the historical context of how this provision was applied, what is a key principle, not only of the founding generation for the U.S., but for the founding generation of Texas? Consent. That, like, I think it was Samuel Adams, if you're going to toy with this idea, it may have been John Locke, if you're going to toy with this idea that government can, for any reason, take your property, it has to be with your consent. And this is one Google search away. This is such an easy thing to find. When that provision was implemented, and I'm going to show you, to this day, it's still the understanding as provided for in the Texas Constitution. That clause, that provision, provided for self-valuations, as in the owner of the property would basically write up a receipt, put right beside it the value of that property or that item, and would send that in to the county assessor. It was called self-rendering, and you're going to see that in Article 8, Section 11, which to this day has not been removed. That was how it was done. So whenever you hear these people go, well, Caleb, they had property taxes back then, that's lying by omission. Because it wasn't a state, it wasn't a county, it wasn't a city that single-handedly said, here's the bill, you're going to pay it. No. It started out with you, the citizen, saying, okay, here's the property I have that you can try to levy some tax on. Here's the value of that property. And then with Article 8, Section 11, it says whatever property you don't offer up, then the tax assessor can take the property you didn't offer and determine whether or not there's a value to assess for that property, which again invades the entire foundation of what the founding generation called the sole and grand end of government and society, which was the preservation of property. Going on too long of a tangent just on Article 8, Section 1B. Let's move on to Section C. The legislature may provide for the taxation of intangible property and may also impose occupation taxes both upon natural persons and upon corporations other than municipal doing any business in this state. The legislature may also tax incomes of corporations other than municipal. Persons engaged in mechanical and agricultural pursuits shall never be required to pay an occupation tax. Is that equal and uniform? No, obviously not. But of course the attorneys are going to say, well, among the mechanical and agricultural occupations, it's equal and uniform. Doesn't matter, because now you're still favoring mechanical and agricultural citizens above non-mechanical and non-agricultural citizens, which is inherently going to be unequal and inherently ununiform or non-uniform. So let's scroll down a little bit further. This is going to be a little bit confusing just because of how it's titled. We are going to, let me find the actual section. It's 1-A. Here we are. 1-A. Okay, the Texas Constitution allows for counties to levy property taxes. It says here, county tax levy for roads and flood control. The several counties of the state are authorized to levy ad valorem taxes upon all property within their respective boundaries for county purposes, except the first $3,000. So is it for any purpose? No. Even if we're going to toy with this idea that the government can take any percentage of your property, it has to be for county purposes. So even if we're going to play devil's advocate and allow the government some portion of entitlement to our property and our belongings, it comes with conditions. Let's scroll down a little bit further, and here's what settles this entire case immediately, without question. Article 8, Section 1-E. Very self-explanatory. State ad valorem taxes are prohibited. No state ad valorem taxes shall be levied upon any property within the state. Well, Caleb, what about the preceding section? It doesn't matter. It doesn't matter what any of these sections say. Section 1-E, finally a section upholding those foundational principles, says verbatim, no state ad valorem taxes shall be levied upon any property within this state. None. So what the state-approved attorneys will do is they say, well, it's not levied by the state. Obviously, the property tax, it's not levied by the state. Procedure-wise, they're correct. It's levied by the appraisal districts. The appraisal districts aren't provided for in the Texas Constitution. The formation of the appraisal districts is not provided for in the Texas Constitution. The Texas Constitution doesn't give the state of Texas to form these districts. It gives the state of Texas the authority to establish counties and cities, but not the authority to establish something like an appraisal district. The appraisal districts aren't constitutional bodies, they're statutorily formed creatures of statute rather than constitutional provision. And their formation is a violation of the powers granted to the legislature in the Texas Constitution. Now, again, what the state-approved attorneys are going to argue is, well, they don't enforce property taxes, when in actuality, they do. The appraisal districts will go to each of the properties and unilaterally determine some arbitrary number that they believe to be a fair market value of the property, and they provide that to the county. The county cannot protest the valuation. The only thing the county can determine is the percentage of charge. The counties don't determine the value of the properties. The counties, they can provide a valuation, but if the appraisal district disagrees, which is an apparatus of the state of Texas, if the appraisal district disagrees with the county's valuations, the county doesn't get to protest. They have to adopt the valuations, the appraisal district, of the valuations of this body of the state of Texas, this statutory creature from the Texas legislature. The appraisal districts, as proxies of the Texas state legislature, are levying ad valorem taxes. The state of Texas, through the appraisal districts, is levying, imposing ad valorem taxes in direct violation of Article 8, Section 1-E. It does not matter what these preceding sections discuss, because no matter what the county or city comes up with for property valuations, the state of Texas, through their appraisal districts, can say, too bad, so sad. You're going to charge a 1% property tax? Okay, this property we valued at $300,000 is now going to be valued at $750,000. That's the trick they play. It's not even a trick, it's just a violation of the Texas Constitution. So no, not only is it a violation of the foundational principles of the ideas that are espoused in the Texas Constitution, in the Texas Declaration of Independence, it's just a blatant violation of the standing Texas Constitution. So let's scroll down a little bit further to Article 8, Section 3. Again, we're going to keep toying with this devil's advocate idea, neglecting all of the foundational principles, neglecting this inestimable, inalienable right to property. If the government is in some way entitled to any portion of your property, the Texas Constitution in Section 3 of Article 8 says taxes shall be levied and collected by general laws and for public purposes only. So if there is any construction that you're not allowed access to, but that is being subsidized by taxes levied on your property, if you don't have access to that property, that public use property, that's a violation of Article 8, Section 3. Because public use, per its inherent definition, is for the use of the public. So if you, the public, don't get to use it, that's not a public purpose. So if they're collecting all of these funds through illegitimate means like levying taxes on your God-given right to property and constructing all of these different projects which you don't get to access, again, not only are they violating the foundational principles, they're violating the Texas Constitution. Let's scroll further down, and here is where you're going to see the evidence of self-valuation that to this day stands as a legitimate form of property taxes. Article 8, Section 11, place of assessment of property for taxation, value of property not rendered by owner for taxation. All property, whether owned by persons or corporations, shall be assessed for taxation, and the taxes paid in the county where situated. But the legislature may, by a 2/3 vote, authorize the payment of taxes of non-residents of counties to be made at the office of the Comptroller of Public Accounts. Here is the important clause. And all lands and other property not rendered for taxation by the owner thereof shall be assessed at its fair value by the proper officer. So whatever property or lands that you don't render, meaning you don't provide a list, meaning you don't offer for, whatever properties you don't submit with valuations to the comptroller, that's when the comptroller goes to the pieces of property or land that you didn't render and provide a fair market valuation. But the first initial phase gives you the authority to self-value, to self-render. And when you look in the historical record, that's corroborated, not only in the times of the Republic of Texas, with the 1845 or the 1836 to 1845 Texas Constitutions, but with the standing Texas Constitution, that you would bring to the comptroller a receipt of your properties and the values you believe the properties are valued at. And whichever ones you don't list, that's when the assessor can look at the properties, look at the possessions you have, and then provide a valuation that they estimate. That doesn't mean that's the definitive value, because you can still protest it. But the first initial phase starts with you providing a list of the property and its value. That is standing to this day. So now we need to get into the understanding of Texas law regarding the total ownership, or the category of ownership that you have over your land. Of course, according to fundamental principles, you have absolute authority. According to Blackstone, you have complete despotic, what was the other word? Sole despotic dominion over that portion of the world, which no one in the entire universe can invade upon. The Texas Tax Code definitions 1.04 says property means any matter or thing capable of private ownership. And how do they determine the valuation? How do they determine the estimate upon which a percentage is going to be taken or demanded of you to surrender? They do it through a market value, which means the price at which a property would transfer for cash or its equivalent under prevailing market conditions. If exposed for sale in the open market with a reasonable time for the seller to find a purchaser, both the seller and the purchaser know of all the uses and purposes to which the property is adapted and for which it is capable of being used and of the enforceable restrictions on its use, and both the seller and purchaser seek to maximize their gains, and neither is in a position to take advantage of the exigencies of the other. So what does even that definition recognize? There's a buyer, and there's a seller. Does the seller get to unilaterally determine the price of the product? Well, yes, but if it's set too high, you're not going to have a buyer. If it's set too low, then of course the seller is probably not going to sell it. Does the buyer get to unilaterally determine the value of the product? Absolutely not, because then that entitles the buyer to whatever property, whatever product that they desire, at whatever price they desire, which embodies that idea which is maintained in Article 8, Section 11. That if we're going to toy with this idea that the government is in any way entitled to a percentage or a portion of your property, you have to have some authority, most of the authority, in determining what percentage the government's going to take. Otherwise, they're not only violating the foundational ideas of a republic-free government, they're violating the Texas Constitution. In a market, the market value is inherently speculative, which is going to play very importantly to when we actually go about determining how you, the individual citizen, can combat this irrefutable invasion of your God-given rights. Before we get to that, and please remember that, so now we have two things on the forefront of our mind. Property is an inestimable, I got to work on that word, inalienable, eternal, God-given right. You have sole despotic control over your property, exclusive of any influence from anybody else. Even if you're going to give up that property, it has to be with your consent. So that has to be on the forefront of our mind. Equally, we need to remember market value. That's how the government is determining what amount of money you're going to surrender or have your property confiscated. The Texas Property Code is what defines, specifically 5.001, defines what the Texas government believes to be your limit of ownership on your property. Now, this statute is actually a violation of course, the Texas Constitution, but definitely of the founding principles in the Texas Declaration of Independence. It says here in Texas Property Code 5.001, you have a fee simple ownership. A fee simple ownership means you have virtually total control of your property, but of course with conditions and exceptions. Is this a legitimate understanding? No. Is it constitutional? No. Is it legal? No. Is it binding? No. Because if there are conditions to your property, your persons and your possessions, are you secure in them? No. If there are conditions to your property, that you can supposedly be deprived of your property for any other reason except by due course of law, are you provided due course of law? No. And because this violates not only the founding principles, but the Texas Declaration of Independence and the Texas Constitution, can it be enforced and applied? Not according to Article 1, Section 29 of the Texas Constitution, which says Sections 9 and Section 17 of Article 1 cannot be violated, and any laws contrary to them are null and void. But here is the default ownership standard that you have whenever you purchase land and property in Texas. It says fee simple. An estate and land that is conveyed or devised is a fee simple unless the estate is limited by express words or unless a lesser estate is conveyed or devised by construction or operation of law. Words previously necessary at common law to transfer a fee simple estate are not necessary. So the default is you have a fee simple ownership of your property, of your land. Is that constitutional? Is that legitimate? Obviously not. If we apply the founding principles, the founding documents, the Texas Constitution itself, you have a fee absolute ownership of your property, which means, like Blackstone said, you have the sole despotic dominion over your property, free of any intrusion from any man, society, or government. In fact, when a society or government tries to encroach on that right, you no longer owe obedience to that legislature, because that entire legislature's purpose is to preserve your right to property. Okay. So I hope you remember the market value definition. Buyer, seller. Markets are inherently speculative. That's why prices change. That's why prices inflate and deflate. Is the founding principles, the founders, and the people who influenced those founders said life, liberty, and property are inalienable. Which means you do not, first, you don't get to invade on them at all, whether you're a government or an individual. But even if you were to, you're certainly not going to do it through a speculative, arbitrary means, like a market. Houses, land, all of those values change and are dependent on the buyer, the seller. The seller determines the price, so the seller would be you, the citizen, and the buyer decides whether or not that price fits. Okay. So now we've got those on the forefront of our minds. Property is an inalienable right. If it's to be invaded, it has to be done with your consent. If it's going to be done with your consent, any compensation that's to be given to you cannot be based on speculative means. And that's not just a principle theoretical grounding. It's actually rooted in the Texas Rules of Evidence. Speculative evidence is not permitted. So we're going to scroll down to Rule 403, which says excluding relevant evidence for prejudice, confusion, or other reasons. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, like a valuation from the state, because the higher the price, the more the state, not the county or the city. You could make an argument if the county and the city still got to determine the valuations, maybe they in some way benefit, but realistically it benefits only the state. The state assessor determining what the value of your property is going to be, giving them encouragement to greatly inflate the value of your property, so that way they can charge you more tax. Unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Further down to Rule 602. It says, you have to have a need of personal knowledge. So do these assessors, have they gone to the owner of the home like they're supposed to, according to Article 8, Section 11, and asked, what do you think the value of this property is? Do they have any first-hand knowledge as to the true value of that property? Do they know first and foremost that they can't tax the inestimable and inalienable God-given right to property? Rule 602 says a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony under Rule 703. Further down, we go to Rule 702. Excuse me, I forgot to get the page number. There we go. So we go down to 702. 702. Untie my tongue. Good grief. Testimony by expert witnesses. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. Are markets ever factual? Never. Their entire nature, especially the property market, the estate market, housing market, it's all dependent on whatever a buyer is willing to pay. And the seller, whatever the buyer is willing to pay, the seller will sell at. But what if a seller doesn't intend to sell? Does the owner of the property or the product or the service, is he in any way required to still sell? If the owner of the house, the land, has no intention to sell, thus not put it on the market, how can you possibly give it a market value? The market value would be zero because it's non-purchasable. Or it would be infinite because it's non-purchasable. That would be the true valuation of the property. That would be the fact. Rule 703, basis of an expert's opinion testimony. An expert may base an opinion on facts or data, facts, not speculative markets that change minute by minute, on facts or data in the case that the expert has been made aware of, reviewed, or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion that would, in its probative value, outweigh the justice that it could provide, because we're talking about confiscating people's property, their inalienable right to property, invading on their God-given rights to property, an opinion on the subject, they need not be admissible for the opinion to be admitted. Okay. So we have the definition of market value, which is speculative. We have the Texas Rules of Evidence saying you cannot submit speculative evidence. We have the founding generation. We have the founding principles. We have the Texas Declaration of Independence. And we have the Texas Constitution, all reinforcing this idea that you have an eternal, inestimable, inalienable right to life, liberty, and property. And that even if we're going to toy with this idea that government has any entitlement to any portion of it, even though they're not the grantee or the grantor, they're not a party to the buyer-seller market, even though they have no influence, no involvement in that market transaction, even if you're going to surrender a portion of that property, it has to be with your consent. It has to be with your valuation. Now that we have all of that in the forefront of our mind, I want to quickly remind you, appraisal districts are not constitutional creatures. The Texas Constitution allows for the formation of counties and cities, counties with Article 9 in the Texas Constitution, and then cities in Article 11. It does not allow for the creation of something like an appraisal district. The state government, whenever it enacted the Texas Tax Code, I think it was 6.01, I'll put a picture up here, 6.01, forming the county appraisal districts, that violated Article 8. Specifically, Article 8, what was it, Section 1-E. Because through these state statutory formed creatures, the state of Texas is forcefully, through the valuations of these appraisal districts, levying an ad valorem tax on the citizens, which the Texas Constitution irrefutably prohibits. So now that we have that reminder that the state of Texas is absolutely levying an ad valorem tax in violation of Article 8, Section 1-E, we have those founding principles, we have the Texas Constitution on our side, we have the Texas laws on our side, we have the Texas Rules of Evidence saying that these assessors cannot admit in court, admit in any sort of realm of law and reason and logic, these speculative or speculative dependent market values, Now that we have all of that information put together, let's actually address how we can go about contesting this. Because it seems like no matter who is elected, no matter who is appointed, property taxes, despite its illegality, its unconstitutionality, and its inherent illegitimate existence, the Texas legislature is refusing to uphold their oaths to the Texas Constitution and, of course, the founding of the Texas government and eliminate property taxes. So the way that you, the individual citizen, can help in abolishing this violation, invasion, and encroachment of your God-given rights is through protest. Now, it's going to take time, and it's going to be maybe a little confusing, but hopefully this lecture will help provide some clarity, and if you have any further questions, please post them down in the comments. The first step that's going to happen, is in April or May of every year, you're going to receive a notice of appraised value. And no matter if it comes from the city, no matter if it comes from the county, maybe even if it comes from the appraisal district, the county appraisal district, no matter what header is on that page, you can know for absolute certain that that value you've been sent isn't a value that's going to benefit your city or your county. It's one that's required by the state in violation of the Texas Constitution. So you're going to receive this notice of approved value in April or May. After that, you're going to file a Form 5132 with the appraisal district within 30 days of the notice of appraised value being mailed, not within 30 days of you receiving the appraised value, but the appraised value notice being mailed. That's your time frame. After that, request an informal conference with the appraisal district. This could be by phone. It's very informal. Can be by phone, can be by teleconference, could be in person. Request an informal conference with the appraisal district. This is where you're going to basically present the argument that I'm presenting here. The founding generation did not endorse anything remotely close to eminent domain. Did not endorse this idea that government is in any way entitled to your property or any proportion or percentage of it, or this speculative value that's arbitrarily made up. That the founding generation didn't endorse this idea, that the Texas Declaration didn't endorse this idea of a property tax, and that to this day, the Texas Constitution doesn't endorse this idea of a property tax. And that even if there's going to be a property tax, it has to include your self-valuation. That's where you'll present the arguments first. After that, after the informal hearing has concluded, if the appraisal district doesn't reverse their valuations, then you're going to request all evidence from the appraisal district. They have to supply the evidence that they used in coming up with this arbitrary valuation of your property. It's basically a guarantee that all of it's going to be speculative. Because again, markets, the transaction between buyer and seller, are inherently speculative. So request all evidence from the appraisal district involving your property's valuation, and the evidence must be provided at least 14 days before the appraisal review board hearing. You will receive this notice from the appraisal review board at least 15 days in advance of the appraisal review board hearing. Now, you can file for counsel. That's a different form. I think it's 50-162. If this seems a little intimidating, I would encourage you to learn how to present and defend yourself. Present your own case. That was one of the big reasons I went and formed the Calhoun School of Law, because if you go to a state-approved attorney, if you go to a state-approved counsel, what are they going to say? Well, of course the state can do that. Well, of course we don't need to listen to all of these people who basically built the state government. We don't need to listen to them. We don't need to consult the Texas Constitution. Of course, the state of Texas can do it. They've been doing it for so long. They've been doing it since the Republic of Texas era. They won't mention the self-valuation and self-rendering part. That's what they're going to tell you. And they tell you that because if they don't, they get in trouble with the Texas State Bar. Their livelihood, their job, and their title depends on their endorsing and advocating the ideas and the advancements of the state. So if you have any questions about this process, any concerns, please post them down in the comments. So once you receive the notice from the Appraisal Review Board determining when and where the hearing is going to be heard, of course you need to attend. And at this hearing, you're going to offer the same arguments that you made during the informal conference. So you're going to bring up Samuel Adams. You're going to bring up John Locke. You're going to bring up Blackstone. You're going to bring up John Adams, James Madison. If you need more examples of the founding generation condemning something like property taxes through their advocacy of property being an unalienable right, let me know and I can provide more examples. The only reason I didn't hear is because I see we're already reaching the hour-and-a-half mark, and I'd like to keep this somewhat digestible. But that's where you're going to present these arguments. The right to property is inestimable, inalienable, and you have sole despotic control, dominion over that property, exclusive of the influence of anybody else in the entire universe, to use Blackstone's words. You're going to reference the Texas Declaration of Independence, and you're going to reference those sections in the Texas Constitution. And you're going to expose that the state of Texas is actually levying ad valorem taxes through the unconstitutional entities known as the county appraisal districts. After that, after the hearing, within 30 days, the Appraisal Review Board is going to issue an order regarding your protest. Either they're going to rescind their valuation, their speculative, unfactual, prejudicial valuations, or they're going to uphold the illegitimate, illegal, unconstitutional valuations of your property. If they do that, then you can file a petition for review in the state district court, which has jurisdiction over the property in question, the property that the valuation was provided against. That has to be filed with that district court within 60 days of receiving the Appraisal Review Board's order. So not when it was mailed, when you received it, when you got it. So whenever it hits your mailbox, from then you have 60 days to draft up a petition for review, file it with the state district court, which has jurisdiction over the valued property. And from there, in that petition, you're going to make similar arguments. You're going to appeal to Article 8, Section 1-E. You're going to elaborate on how the state of Texas is, in fact, levying an ad valorem tax, an unrealized capital gains tax. All of these things which the Texas Constitution to this day prohibits, that you were never consulted before the valuations were sent to you, that you didn't render or were involved in the rendering and valuations of the property. All of these different arguments that we've been going through with this lecture is what you're going to present in that petition for review. Or if you have better arguments, put that in the petition as well. So that is all I have for you for this lecture. And for those who aren't in a Texas context, those ideals weren't just Texas specific. Sure, the Texas Declaration and the Texas Constitution and the Texas laws, all that's going to be Texas specific. But what Blackstone, what John Adams, what Samuel Adams, what John Locke and James Madison were saying about property, that's a universal principle. What was complained about, the king and the monarch taking property, confiscating property from the colonists in the original draft of the U.S. Declaration of Independence, that wasn't just aimed towards Texas. That's a universal principle. So while the Texas part and the Appraisal Review Board and the procedural part of this lecture may not apply to you, the beginning of this lecture certainly does. You have an inalienable, inestimable right to sole despotic dominion over your property, exclusive of any influence from any man, any government, any society. Further, if and when a society tries to invade on that property, you no longer have any duty, any obligation to obey that legislature. And what you'll hear, again, from these state-approved attorneys is, okay, even if you find one with some amount of dignity that recognizes the Texas Constitution, willing to take up this case for you, even when you go and find that individual, and if you do, please send him my way. I'd love to have a conversation with him. What's likely going to be told to you is, well, you should go ahead and pay the property tax. And then if it comes out that it was illegitimate, then you're just going to be refunded. What I would tell that attorney and what I would tell you is there's not historical precedence for that. In fact, the opposite procedure is the true one. If you remember, the founding generation didn't comply with the illegitimate taxes before they rebelled, before they contested the acts and the taxes' legitimacy. Remind yourself of that. They didn't comply with the encroachments first and then hoped they would be compensated and reimbursed for the transgressions of the government. No. They didn't comply. And then the government had to prove that they had the authority to do what they did. And ultimately, the government couldn't do that. So that would be my advice to you. It may be unpopular. It may make the state-approved attorneys cringe. But that's what the founding generation did. And that's what's ultimately required to make sure governments and societies don't successfully encroach upon your inestimable, inalienable, eternal law of reason, God-given rights. That would be my advice to you. Do not pay. At least in terms of the Texas context, the Texas Constitution endorses that idea with Article 1, Section 19, that you can't be deprived of life, liberty, and property without due course of law. So why pay something that before due course of law hasn't been legitimately decided to be worthy of depriving you of your property? So no, there is no claim, there is no backing, there is no support, legal, historical, constitutional, that would encourage you or advise you to just comply with the encroachment and then hope and pray that the government is going to exercise good wishes and a better will. Never been the example. That's never been advised. Certainly not by the founding generation. But I've already gone on too long. If you have any questions about this topic, if you'd like more information, maybe more examples from the founding generation, there are dozens of examples. I can very quickly recite those to you. If you think I'm just totally off my rocker here, or maybe there's a different legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.